You committed a nonviolent felony 20 years ago. You served your time. You paid your debt to society. You've been a law-abiding citizen ever since. But you can never own a gun again, ever. Because federal law says if you've been convicted of any felony, violent or nonviolent, you're a prohibited person for life. You cannot buy, own, or possess firearms. And on March the 2nd, 2026, the Supreme Court had a chance to change that. A woman named Melynda Vincent from Utah challenged the ban on nonviolent felons owning guns. She argued it violates the Second Amendment. Her case made it all the way to the Supreme Court, and the court said no. They declined to hear the case. Cert denied. That means the ban stands. Millions of nonviolent felons remain prohibited from owning guns, and for now there's nothing they can do about it. This is a loss for gun rights, but it's not the end of the story. Because cert denial doesn't mean the court thinks the law is constitutional. It just means they're not ready to hear the case yet. And that leaves the door open for future challenges. And we need to understand what just happened and what it means for the future. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal affects millions of Americans with felony convictions who've been permanently stripped of their gun rights. The Supreme Court just declined to hear this case, but that doesn't mean the issue is dead. Future challenges are coming. Hit that subscribe button right now so you never miss updates on when the court might finally take a case like this. Here's what happened and what it means. Melynda Vincent is a woman from Utah. Years ago, she was convicted of a nonviolent felony. The details of her conviction aren't public, but it was something like fraud or drug possession, not a violent crime. She served her sentence. She completed probation. She's been clean ever since, but under federal law, specifically 18 U.S.C. Section 922 G1, anyone convicted of a crime punishable by more than 1 year in prison is prohibited from possessing firearms. It doesn't matter if the crime was violent or nonviolent. It doesn't matter if it happened 30 years ago. Once you're a felon, you're banned for life. Melynda wanted to own a gun for self-defense, but the law said no, so she challenged it. Her lawyers argued that the lifetime ban on nonviolent felons violates the Second Amendment. The argument was simple. Historically, governments only disarmed people who were dangerous, violent criminals, people who posed a threat. But nonviolent felons? There's no historical tradition of permanently disarming them. So under the Supreme Court's test in Bruin, which requires gun laws to have historical analogs, the ban on nonviolent felons is unconstitutional. The case went to federal court. The district court ruled against Melynda. The court said felons have always been prohibited from owning guns. The case was appealed to the 10th Circuit. The 10th Circuit also ruled against Melynda. The court said the government has a strong interest in keeping guns away from people who've proven they can't follow the law. Melynda petitioned the Supreme Court for certiorari. That's a request asking the court to hear the case. And on March 2nd, 2026, the court denied cert. They refused to hear the case. The 10th Circuit's decision stands. The ban on nonviolent felons owning guns remains in effect, and Melynda lost. Now here's what cert denial means and what it doesn't mean. When the Supreme Court denies cert, they're not ruling on the merits of the case. They're not saying the law is constitutional. They're just saying, we're not going to hear this case right now. The court denies cert in about 95% of cases. They only take 70 to 80 cases per year out of thousands of petitions. So denial is common, but it's still significant. It means the issue is not going to be resolved by the Supreme Court anytime soon. The lower court's decision stands, and people affected by that decision are stuck. For Melynda and millions of other nonviolent felons, this is bad news. The ban continues. They cannot own guns, and there's no immediate legal path to change that. But cert denial is not permanent. The court can take a similar case in the future. If another nonviolent felon challenges the ban in a different circuit, and that circuit rules differently, creating a circuit split, the court would be more likely to take the case. Or if the legal landscape changes, maybe after the court decides other Second Amendment cases, they might be ready to address this issue. So the door is not closed, it's just not open yet. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down which types of felons might successfully challenge the gun ban and which ones won't. There's a difference between violent and nonviolent felons in terms of legal strategy. Subscribe right now so you don't miss it. Now let's talk about why the court denied cert. We can't know for sure because the court doesn't explain cert denials, but based on the case and the legal context, here are the likely reasons. First, there's no circuit split. The circuits that have addressed this issue have mostly upheld the ban on felons owning guns. There's no disagreement between circuits that would require the Supreme Court to step in and resolve. Second, the issue is complicated. The historical analysis for felon disarmament is messy. Some historians say there's a tradition of disarming criminals. Others say the tradition only applies to violent criminals. The court might not be ready to wade into that debate yet. Third, the court might be waiting for a better case. Melynda's case might have had procedural issues or factual problems that made it a bad vehicle for addressing this question. The court often waits for the perfect case before taking an issue. And fourth, the court might not want to open the floodgates. If they strike down the ban on nonviolent felons, what about other prohibited categories? Drug users, people under restraining orders, people with mental health adjudications? The court might want to go slow and not disrupt the entire prohibited persons framework all at once. Now, quick legal note, this is educational information, not legal advice. If you're a felon and you're thinking about challenging your gun prohibition, consult with an attorney who specializes in firearms law and criminal law. These cases are complex. Do not try to own guns based on this video. The law is still in effect. Violating it is a federal crime. Now let's talk about the law itself, because it's important to understand what we're dealing with. And again, for the rest of his life, through the gun ban, he wanted to challenge it. But after the Supreme Court denied cert in Melynda Vincent's case, John knows his chances are slim. He's stuck. Now imagine a different scenario. Imagine a woman named Sarah. Sarah was convicted of a nonviolent drug felony 15 years ago. She had a small amount of drugs for personal use. Under mandatory minimums, she got a felony conviction. She served probation. She's been clean ever since. She's a single mother. She lives in a rough neighborhood. She wants a gun for self-defense. But the law says no. Sarah is terrified. She's heard gunshots outside her apartment. She's had break-in attempts. She feels helpless. And the government tells her she can't protect herself because of a mistake she made 15 years ago. That's the injustice of the lifetime ban. It doesn't account for rehabilitation. It doesn't account for the nature of the crime. It treats all felons the same, whether they're violent predators or nonviolent offenders. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about the historical argument, because this is key to understanding why future challenges might succeed. The government argues there's a long tradition of disarming criminals. Colonial laws prohibited felons from owning guns. State laws in the 19th century did the same. So the modern federal ban is consistent with that tradition. But gun rights advocates say that's not accurate. They point to historical research showing the laws disarmed violent criminals, not all criminals, someone convicted of fraud or theft or a nonviolent offense. They weren't disarmed. Only people who'd committed crimes involving violence or who posed a danger to public safety were prohibited. So a blanket ban on all felons, including nonviolent ones, has no historical analog. Under Bruin, that means it's unconstitutional. The problem is, the historical record is mixed. Different colonies and states had different laws. Some were broad, some were narrow. It's not a clean picture, and courts are split on how to interpret it. That's why this issue needs to go to the Supreme Court. But the court isn't ready yet. Let me give you another example. Imagine a guy named Tom. Tom was convicted of felony tax evasion 20 years ago. He didn't pay his taxes. It was a crime, but it was nonviolent and had nothing to do with guns. Tom served his sentence. He's paid his taxes ever since. Now Tom wants to buy a gun. He goes to a gun shop. He fills out Form 4473. Question 11B asks, have you ever been convicted of a felony? Tom has to answer yes. The dealer runs the background check. The check comes back denied. Tom can't buy the gun. Tom is frustrated. He says, my crime had nothing to do with violence or guns. Why am I treated the same as a murderer? The law doesn't distinguish. That's the problem. Now let's talk about what happens next. Will another case reach the Supreme Court? Probably. Gun rights organizations are actively looking for plaintiffs to challenge the nonviolent felon ban. They want someone with a sympathetic story, someone who committed a minor nonviolent crime decades ago and has been a model citizen since. Someone who genuinely needs a gun for self-defense. If they find the right plaintiff and the right facts, they'll bring a case, and they'll appeal it all the way to the Supreme Court. Maybe in 2 or 3 years, the court will be ready to take the case. What will the court do if they take it? Based on recent Second Amendment decisions, here's my prediction. The court will distinguish between violent and nonviolent felons. They'll say the government can permanently disarm people convicted of violent crimes. There's historical support for that. But nonviolent felons are different. The government can restrict their gun rights temporarily, maybe during probation, but a lifetime ban has no historical analog. So the court will strike down the ban as applied to nonviolent felons. They won't strike down the entire felon prohibition, just the part that applies to people whose crimes didn't involve violence or dangerousness. That's my prediction, but we're years away from that. This information could literally determine whether you ever get your gun rights back if you're a nonviolent felon. Subscribe now, because my next video explains the exact process for trying to restore your gun rights through presidential or gubernatorial pardon. Hit that subscribe button. Now let's talk about the numbers, because this affects millions of people. There are about 20 million Americans with felony convictions. Not all of them are in prison. Most serve their time and are back in society. Of those 20 million, A significant percentage are nonviolent offenders. Drug crimes, fraud, theft, white-collar offenses. All of them are prohibited from owning guns under 922G. They're one. That gives millions of Americans who've been permanently stripped of their Second Amendment rights for crimes that had nothing to do with violence. And the cert denial in Melynda Vincent's case means they're stuck, at least for now. Now let's talk about what nonviolent felons should do. First, don't try to own guns. The law is still in effect. If you're caught, you're going to prison. It's not worth the risk. Second, consider applying for a pardon or expungement if your state allows it. Some states have processes for clearing felony convictions after a certain number of years. If you can get your conviction expunged, you're no longer a prohibited person. Third, support gun rights organizations that are working on this issue. Donate to groups like the Firearms Policy Coalition, the Second Amendment Foundation, or the NRA. They're funding legal challenges. The more resources they have, the more cases they can bring. And fourth, stay informed. Follow the legal battles. When a new case challenges the nonviolent felon ban, pay attention. If it goes to the Supreme Court, that's your chance. Now, let's talk about the political angle. Gun control groups were relieved by the cert denial. They put out statements saying felons are dangerous and shouldn't have guns. But gun rights groups were disappointed. They said the court missed an opportunity to correct an injustice. The divide reflects the broader gun debate. One side thinks public safety trumps individual rights. The other side thinks rights are rights, even for people who've made mistakes. Now let's talk about the contrast with violent felons. If someone was convicted of murder, assault, armed robbery, or another violent crime, can they ever get their gun rights back? Probably not. Even if the Supreme Court strikes down the ban on nonviolent felons, violent felons will almost certainly remain prohibited. Why? Because there is historical support for disarming violent criminals. Historically, people who committed crimes of violence were seen as dangerous and were disarmed. That tradition continues today, so violent felons shouldn't expect relief from the courts. But nonviolent felons have an argument. Their crimes didn't involve violence. They're not inherently dangerous. And the historical tradition of disarming criminals was targeted at violent offenders, not everyone with a felony conviction. That's the distinction the courts will have to grapple with eventually. Look, I spend hours every week tracking cert petitions, reading denial orders, and analyzing why the Supreme Court takes or rejects cases, so you understand when the court is ready to address an issue and when it's not. The least you can do is subscribe to make sure you never miss the announcement when the court finally takes a nonviolent felon gun rights case. Subscribe right now, and if you found this helpful, share it with anyone you know with a nonviolent felony conviction. They need to understand where the law stands and what might change in the future. Spread the word. Remember, this is educational information based on the Supreme Court's denial of certiorari in Melynda Vincent's case. It is not legal advice for your specific situation. The federal prohibition on felons possessing firearms is still in effect. Violating it is a federal crime with severe penalties. Always consult with an attorney before making decisions about gun ownership if you have a felony conviction. Stay informed, stay hopeful. And understand that while this case was denied, the fight for nonviolent felons' gun rights is far from over. Future cases are coming. And one day, the Supreme Court will take one. When they do, millions of Americans might finally get their Second Amendment rights back.